appeal in the matter of Ghaoui and London Borough of Waltham.
Yes, Miss Davies.
My Lords, I appear for the appellant in this matter with Mr Gannon behind me, and Mr Mullins appears for the respondent with Ms Taylor-Waller. My Lords will be aware that this appeal, which is in respect of a review decision of the suitability of accommodation offered to my client under homelessness functions, it's now academic.
Yes.
My client's very commendably managed to find his own accommodation. And my Lords, it's not in the bundle, but Lady Justice Andrews made an order on the 7th of March that the appeal, giving permission for the appeal to continue, with a provision that if the appeal succeeds, the appellant may not recover costs from the respondent. So there we are.
I mean, just on that note, I know that the skeleton argument was provided before it became academic, but I mean, in a sense, let's suppose the appeal was to succeed. Is there any relief in fact that we would be?
We've discussed that, and we're both of the view that if the appeal succeeds, then clearly the judgment below should be set aside. But in terms of relief as against Waltham Forest, that, my Lords, that this court has the power to vary the decision, and you could vary the decision to one that the Section 193 main housing duty has come to an end because the appellant no longer occupies that accommodation, and that's within the structure of Section 193. So that would allow, in effect, his homeless application to have concluded. So we're both agreed that that would be a sensible outcome if the appeal succeeds.
Right, so it doesn't lead to anything being done about the review decision, it's just the file is closed.
We're agreed that it would be a waste of time and expense of public money in order for even to ask the review officer to come to what we say is an obvious decision as a result of the change of circumstances. So there we are. Thank you. Can I deal with housekeeping? My Lord should have a core bundle, a supplementary bundle, a bundle of authorities, and we have handed in 2 additional authorities paginated today. So I don't know if there's been an opportunity for those to be added to the bundle. At least there are paginated.
Here on paper for us all, I think.
Good.
Yes.
And the skeletons, they appear in the core bundle. Mine is at page 60 and the respondent's is at page 40, and there is a chronology at page 58 of the core bundle.
Well, you can take it that we've studied those. You needn't spend a minute of your time telling us what's happened, what the background is, what the chronology is, what the review said, what the judge said. You can take it that we securely have all the information that you've between you, you've very carefully put together. So if it's convenient to you, without wanting to stop you from drawing out anything that's of particular importance, you're welcome to move straight to the argument.
I'm grateful for that. So I will go. My Lords, I was intending to do a review of the authorities on homelessness, but I will skip that given the indication. It would be helpful, I think, for me to say a few words about the authorities on the human rights approach before I then come to the 3 grounds.
Certainly.
So, my Lords, we have the Human Rights Act in the bundle of authorities. I'll give you, my Lords, the page references, but clearly I know you're deeply familiar. Section 6, which is at page 72, it's unlawful for a public authority to act in a way which is incompatible with the convention right. As far as Article 9 is concerned, there is special protection in respect of court decisions at section 13, and that's page 80. If a court's determination of any question arising under this act might affect the exercise by a religious organisation itself or its members collectively of the convention right to freedom of thought, conscience and religion, it must have particular regard to the importance of that right. And then, my Lords, Article 9 is at page 97, page 93, and we're concerned with Article 9.2. Well, we're concerned with both 1 and 2. Everyone has the right to freedom of thought, conscience and religion This right includes freedom to change his religion or belief and to manifest his religion or belief in worship, teaching, practice or observance. And then at Article 9.2, the freedom to manifest one's religion or beliefs, subject only to such limitations as are prescribed by law and necessary in a democratic society, the usual justification. And my lords, Article 2 of the first protocol is at page 96. And we are concerned with the second sentence of that, in the exercise of any functions which it assumes in relation to education and teaching, and I will need to come back to that point, my lord, the extent to which the local housing authority might be exercising those functions. The state should respect the right of parents to ensure such education and teaching in conformity with their own religious and philosophical convictions.
Yes.
And there is the reservation at page 97, only so far as compatible with the provision of efficient instruction of training and the avoidance of unreasonable public expenditure. My lords, I'll develop the point, but I will say it's clear that a wish to have one's children educated in a certain faith is a manifestation of one's religious belief.
I don't think there's any dispute about that.
No. My lord, the first domestic authority is the case of Williamson.
Before we go to the authorities, what's the proposition you're about to make good?
My proposition broadly is this, and it is ground one, which is that his preference, which is how it was put, both in the submissions made by him, by his solicitor, and then that word was adopted by the reviewing officer, that his preference was clearly a manifestation of his belief. That the reviewing officer for the local authority should therefore have recognised that. She should therefore have gone through a process of considering whether the decision that he should have accommodation in Harlow, where there were no Islamic schools, or there's certainly no evidence that there were any, that's not the case, was an interference with that right.
So I was just writing while you were talking that the reviewing officer should have recognised that the choice of school was a manifestation of belief, and should have. I then lost the thread.
Should have recognised that accommodation in Harlow, where there was no Islamic school, was an interference with that.
So that's, I think that's different from what you were saying a moment ago, because I got as far as process of, but that's not the proposition. The proposition that you were putting now was that she should have recognised that accommodation in Harlow was an interference.
Yes. Accommodation where he could no longer send his child to an Islamic school was an interference.
Because could no longer send child to school.
Yes.
Now,
having recognised that there was an interference, then there should have been a justification exercise carried out under 9.2.
And taking it out of your course, I saw in the judgment below that the judge records that it was said to her that if the review officer had mentioned Article 9 and the decision, that would be fine. Is that your case?
That's not my case, my lord, and I accept for the purposes of human rights the authorities in respect of public sector equality duty to the effect that it's substance, not the reasoning process is about, and the lawfulness of it is about substance, not form, that there doesn't have to be a statement of the public sector equality duty, or in our case, Article 9. And I also say that the converse applies. Clearly, if there was just a reference to Article 9, that's not sufficient. The question is whether or not the right to respect for his manifestation of his religious belief was recognised as such, and then the appropriate exercise, and then the failure to exercise, we say, is a breach of Article 9 in itself. If it had been recognised, then the appropriate reasoning should have been to go through the questions of interference and justification.
So just to understand, with the public sector equality duty, you have to be aware that it exists. But once you've done that, well, you don't worry any further, potentially. In this context, plainly you say that the review officer had to have regard to the preference to have accommodation within reach of the school.
Yes.
Do you say that the review officer had to be aware of Article 9?
She had to be aware of the substance of Article 9, and she had to treat that preference with respect.
And let me just understand that. If she treated the preference with respect, but knew nothing about Article 9, is that all right?
Well, it depends what she says.
Well, does it? Because presumably your complaint is not about what she says, it's about what she thought.
Well, my complaint is about what she wrote, the decision in itself, and insofar as it's what she thought, it's how those words show her thinking process. But the complaint is about what's on the face of the review decision, and whether the face of the review decision shows any respect for the manifestation of
I
his
wonder,
belief.
is respect the right the right formulation of this? I mean, we know that, for example, in some parts of the convention, that the concept of respect for
Right. Yes.
private life is built in there. Is what you're really saying that she had to be aware of the substance of Article 9 and give appropriate weight
Yes.
to it as it applied in the present case?
Yes, it may be that I'm using respect as shorthand
Well,
inappropriately.
respect is a sort of rights type term.
It is, yes, but it's not in Article 9.
It's not in
Specifically.
Article 9,
No.
but I mean, you wouldn't object in that case if we noted your submission as that she ought to have been aware that this was an issue and given appropriate weight to it.
Yes, and that it was an issue that I'm going to fall back on the word respect, in fact, although it's not in Article 9, but that somebody's manifestation of their religious belief certainly has weight and should be respected, subject to the structured approach that Williamson and the subsequent cases of SB and Denby, and then indeed the case of Michaela 2 days ago, apply to the, is there a manifestation, is there an interference, and then is there justification? And even if she didn't use those words, as well as my Lord Justice Newey's point about not using the words of Article 9, she didn't need to use those words, but she did need to approach that decision about the significance of the children attending the Islamic school in that way, whatever the wording of that reasoning turned out to be. But one should be able to ascertain that that was her, and again, Lord Justice Newey's thought process from the words of the review decision.
All right, well now, tell us next, if you would, how are we going to be helped by going to the authorities? Because I mean, we're concerned here with a review decision on the question of suitability.
Yes.
And we're considering, as I understand it, the appeal on the basis of what was there a public law error in the review decision,
Yes.
which had to be made within the framework of the rights of the individuals
Yes.
concerned. So, I mean, obviously, we're aware of the major decisions that have taken, and have reminded ourselves of some of the later ones, which are concerned with the related topics, although none with Article 9.
No.
What is? I mean, before we begin a route march through familiar territory.
We don't need to do a route march.
I just want to know what it's going to lead to, because you very clearly set out, manifestation, interference, justification, and you soundly base yourself on manifestation.
Yes.
Without contest. That the decision that the reviewer had to carry out was a suitability review.
Yes.
And that doesn't necessarily depend upon the issue whether there was interference or not with Article 9. That's not what governs the suitability decision. The suitability decision has got to be taken into all the factors, including the religious factor.
Yes.
And so, the judge found that there wasn't an interference with Article 9.
Yes.
But even if there had been an interference with Article 9, she left open whether it was justified. But even if there had been an interference with Article 9, it wouldn't of itself have vitiated the review decision. That wouldn't have been the end of it.
Yes.
So what would we be gaining, in a sense, by speculating in relation to interference with Article 9, if so, justification? Is it not just one element, and the question for the reviewing officer and the question for us, whether the reviewing officer took sufficiently into account the choice, whether it's expressed as a preference or an important...
I'm happy with the word preference, providing it's not used to diminish the wish. Yes.
It's a serious decision to take to decide that your children should go to a faith school.
Yes.
And so if preference is regarded as being a serious matter, that's not the battleground. I've just unloaded a few thoughts to you, but please take us to whatever authority you think might illuminate and support your contentions in this. But I'm not quite sure what reference to all the big cases about.
As I say, I'm happy not to do the route march. So, 2 points on that. If, as I understand my lord to be saying, first of all, clearly human rights must come within a suitability decision because they are a public authority.
Yeah. And
for that I rely on Section 6. And there is also, interestingly, human rights have really come up in the arena of homelessness law, surprisingly, one might say. But there is a passage in Cadona in respect of Article 8 where Lord Justice Old broadly says it's relevant but adds very little, and that is it's at pages 150.
Should I'm extremely grateful to those who instruct you, who've provided not only the paper bundles but also electronic bundles, and also an index at the front that has links, which is helpful, but bookmarks down the side in future if possible, because I have no way of getting to the decision without going.
Does my lord not have bookmarks?
I've got an electronic bundle, but it's not bookmarked.
Electronic bundle doesn't have. So those of us who are foolish enough to rely on the paper copies do have bookmarks.
I'm in a big minority here, so I'm careful not to overdo it. But it's really helpful with the old electronic bundles to have the bookmarks down the side, please.
That's
right.
Noted.
So we're at page
150.
Right, that's it. Right.
And it's actually 2 pages, but I can summarise it at paragraph 55 of Lord Justice's Old's decision. And my lords will be aware that this was about suitable accommodation for gypsies and the assessment of bricks and mortar accommodation, whether or not it was suitable. And the case is principally used for Lord Justice's old general comments on the authorities on the meaning of suitabilities, which have remained the leading account now for 19 years. But in paragraph 55, in the second sentence, the judge went on to deal with the Article 8 point, put to him as a separate or supplemental ground of complaint, fortifying Mrs. Cadona's claim in much the same way as Mr. Watkinson seeks to argue here as a proposed fourth ground of appeal. And he says, it is, of course, all part of the same question, lawful application of a proper definition of suitability to the circumstances of the case, including her aversion to conventional housing, the fact that the offer was the short stay, bed and breakfast accommodation, and then the judgment is quoted at some length at the bottom of page 150 and 151, and at the top of page 152, paragraph 58. From all of this, I conclude that the counsel and the judge, in the way they respectively approach the effect of Mrs. Cadona's and her extended family's aversion to conventional bricks and mortar, identified the applicable domestic law as I have summarised it, and properly and compatibly with human rights principles applied it to the facts of the case. It's plain too that the judge did not simply consider the Article 8 balance by asking himself whether the council's decision was on the facts one that it was entitled to make, and he formed his own view on the matter. So, and then further down at 60, the council has so far discharged its statutory duty to secure accommodation for the Cadona family and has done so without violation of Articles 8 and or 14. So that is authority, and actually the only authority, if needed, for the proposition that human rights matters do come into the mix of a suitability assessment. So on the basis that it is in the mix and that it has to be considered in the right and lawful manner, again leaving aside exactly what words are used.
Presumably it comes into the mix so far as there's an interference.
Yes.
Well, can I interrogate
my lord,
that?
yes.
I rather doubt that it's the job of a reviewing officer to rule upon whether there has been a breach of one of the convention rights. That wouldn't be an appropriate task for, or interference, whichever one might say. That wouldn't be a task for a reviewing officer to perform. The task for the reviewing officer would presumably be to identify the factor,
Yes.
and then to ascribe appropriate weight to it,
Yes.
mindful if it is a factor which attracts protection, if it's important to recognise that. Go back to our previous discussion,
Yes.
then to recognise it. But if you're in substance recognising it, that won't make a difference. But I wonder, I mean, clearly if the circumstances were such where there was obviously a screaming interference with a right, then not to recognise that would betoken the fact that you weren't giving appropriate weight to the
All the
consideration.
mosques in this town are closed, that sort of thing, yes.
But I wanted your help arising out of your having set up the manifestation, interference, justification part. I think that may be how one looks back on a review decision and considers it, but it's not how the reviewing officer ought to be going about it, is it? The reviewing officer ought to be identifying the appropriate relevant factors for suitability.
For suitability.
And then applying appropriate weight to them.
Including, of course, the recognition, and we come back to the previous discussion, that his manifestation of religious belief is being interfered with, whatever word she uses to recognise that, but she has to recognise the significance of that.
But it wouldn't, I mean, you say it's an element of religious belief. Let's change this case. Let's suppose this was a child who you had a child who was a nervous child,
Yes.
for whom a change of school was likely to be quite a big thing. And so saying that you could take the child from Waltham Forest and plenty of schools in Harlow,
Yes.
a parent might take a very strong view that we've now finally got the child settled
Yes.
in this school,
Yes.
and a lot of weight is attached
Yes.
to keeping the child in the school.
Yes.
Now, clearly that's something that the housing review would have to take account of.
Yes.
But is that very different from is that very different from a situation where you want to keep a child in a faith school?
It is, in that the latter is more significant. So the former scenario, certainly she has to consider that. And she has to do that for two reasons. One is because the 2012 suitability order requires her to consider disruption to education.
Yeah.
And the other is the long line of authorities that make it clear that it is about the individual applicant's individual circumstances, which would of course include the members of his family and so forth. So if she were to say any child would be fine changing school, she would be in difficulty of having committed an error of law. But if she were simply to say, I've considered the circumstances, I've looked at any reports you've put forward that show the undue anxiety, etc., and I'm satisfied that schools in Harlow have had appropriate training, appropriate policies about how to deal with nervous children, or this particular school has a policy, then she would probably not have committed an error of law, because I'm making the scenario up. I don't want to be too clear on that, but that's in effect the reasoning she has to go through, is to consider the individual child and the disruption of education and the effect on that individual child, and she has to do that under the suitability order. The reason why this is different, and in addition to that, is because it is a human right. Because it is protected. The manifestation of religious belief is important enough to be protected under the European Convention, under the Human Rights Act, for a number of reasons, including those set out very cogently by Lord Nichols in Williamson.
So following on from what my lord said, it is, although not necessarily to express it in technical terms or even as a human rights analysis, you say it is essentially the same thing that has to be decided, namely whether there's an interference with the right under Article 9. On the basis that the reviewer doesn't have to do that exercise, so-called, but
she has to be aware of the significance of it, of the weight of it, of the respect that should be given to the manifestation of his belief. She has to be aware of that. What she does not have to do is answer an exam paper on the structure of Article 9, and that's from Lord Hoffman's remarks in SB and Denby, and it's page 517.
Thank you.
And at 66, Lord Hoffman is criticising the submissions for SB, and indeed the Court of Appeal's decision, where he quotes Lord Justice Brooke, that first of all, that the judgment should not be taken as meaning it would be impossible for the school to justify its stance if it was to reconsider its uniform policy in the light of the judgment. But he thought the schools had infringed Sabina's rights under Article 9 because it had not reached its decision by an appropriate process of reasoning. It should have set itself an exam paper with the following question. So Lord Hoffman is deliberately using that language to make the point. Has the claimant established she has a relevant convention right? And we see that there are 6 questions on the exam paper. And Lord at 67, the school's method of working out the problem as disclosed in the witness statements filed on its behalf did not suggest it had adopted this procedure at all. They decided on the uniform policy and so forth. And at 68, another slight jibe at the Court of Appeal, it would have failed the exam, but the whole approach seems to me a mistaken construction of Article 9 in a domestic judicial review, and that's where we are with Section 204. The court is usually concerned with whether the decision maker reached his decision in the right way rather than whether he got what the court might think to be the right answer, but Article 9 is concerned with substance, not procedure. It confers no right to have a decision made in a particular way. What matters is the result. Was the right to manifest a religious belief restricted in a way which is not justified under Article 9.2? The fact that the decision maker is allowed an area of judgment in opposing requirements which may have the effect of restricting the right does not entitle a court to say that a justifiable and proportionate restriction should be struck down because the decision maker did not approach the question in the structured way in which a judge might have done. Head teachers and governors, and I would add review officers, cannot be expected to make such decisions with textbooks on human rights law at their elbow. The most that can be said is that the way in which the school approached the problem may help to persuade a judge that its answer fell within the area of judgment according to it by the law. So yes, clearly Ms. Kasumba didn't have to set herself the exam paper and then answer the questions in that structured way. But she has to know enough of the... I'm so sorry.
Well, I think you're sort of answering my question. So Lord Hoffman says concerned with substance, not procedure. What matters is the result. Was the right to manifest a religious belief restricted in an impermissible way?
Yes.
Now, in that context, why does it matter whether the review officer knew about Article 9 or knew that the convention gave any particular status for religious belief? I mean, don't you, on that basis, have to ask yourself whether the end result is such as to restrict religious belief in a way that isn't justified?
You do, but the end result can only be ascertained through the reasoning of the review officer. And in both SB and the TT and Michaela case from 2 days ago, we had reasoned decisions by the two respective schools about first the uniform policy and then the prayer room policy, in which those decision makers set out a series of facts that subsequently the House of Lords and the Administrative Court found that as a matter of substance amounted to broadly no interference with the right to manifestation, although the House of Lords are split on the question of interference. But they are all agreed on justification. Mr. Justice Linden in TTT finds first no interference, and then, if he's wrong on that, just justification. So in both of those cases, the courts take the facts as found and considered by the original decision makers, the schools.
And in this case, there's no dispute about the facts. The facts are...
Well, there's no dispute about the facts, but there is a real dispute about the decision that primary schools are available in Harlow and that it's appropriate for the appellant to have his children change schools to a non-denominational school.
Yeah, that's a value judgment.
It's a value judgment, but it's a value judgment that the review officer embarks on without going through any sort of the structured process, not an exam paper, but some form of structured process that recognises the significance of the manifestation of religious belief, and then whether it is interfered with, and then whether it's justified. And we say that her reasoning does not stand up to scrutiny of that appropriate test, because she doesn't say, well, I acknowledge the importance of a religious education, I have considered whether it is possible to accommodate that. Or the only accommodation we have available in Harlow is in Harlow, and sadly, there are no Islamic schools in Harlow.
It sounds as if this is, and I quite understand why it might be. It sounds as if this is a complaint about the degree of courtesy that was shown in the expression of the reasons. I mean, I don't mean to pin you down, and I mean, you're no longer saying that if Article 9 had been mentioned, I wouldn't be standing here. I wouldn't stand that, and we're considering the substance of this. But now you appear to be saying that if the reviewing officer had expressed herself in a more decorous manner,
no,
we wouldn't be standing here either.
No, I'm not. I mean, we do complain as aside about the way it was expressed. We consider it was not terribly respectful in the layman sense of the word. But leaving that aside, what we say is that the substance of the decision did not give any respect. One cannot tell from the words in the decision that the manifestation of his religious belief was respected, or given significance, or given weight, however one wants to put it. One also can't tell that there was thought put in. I'm coming back to Lord Justice Newey's point about thought of words, but that there was thought put in to, given the importance of the manifestation of religious belief, can the local authority accommodate it in some way? In that either by looking at all the facts, they decide that it's actually not interfered with. So she could have made a decision that says, I appreciate the importance. You can either change schools, or I've thought about the journey times and I've decided that they're not that onerous for the purposes of having an assured short-hold tenancy in Harlow. She could have said that, and on the basis of their, and on that basis, she doesn't need to go on and say, and therefore it's not interfered with, but she would have effectively made a finding that there isn't an interference with the manifestation of your religious beliefs. We're giving you a choice.
What she, looking at it broadly, she was saying, you're doing it. You can go on doing it if that's what you choose to do.
But she doesn't.
So that's no interference. Or if that doesn't work for you, you can send them to your local school.
If she'd said that, I would be on weaker ground.
But I have to say that, broadly speaking, that's how I read it. I mean, I do take your point about use of language. So far as I'm concerned, you're pushing at an open door there. And indeed, I've wondered where all this would have gone had the conclusions been expressed slightly differently. But we are considering the proceedings as they were brought. But isn't that really what she's saying?
It's we say that's not apparent from the judgment. We say what is apparent from the judgment is she is saying that the having considered.
You mean the review decision?
I'm sorry, I said judgment, didn't I? The review decision. Thank you so much. That having directed herself in accordance with the suitability order about disruption of education, she says there is one answer, and that answer is changing schools. If she had adopted the more subtle approach that my lord has just outlined, we would be in more difficulty, because then, applying the substance not form point, then her decision would have been much closer to the school's decision in SB and TTT. She would have thought about she would have said one option is non-denominational, but another option, by the way, is the journey is manageable, you've been doing it, etc., etc. That doesn't come over. What comes over from the review decision is neither the homeless legislation nor the suitability order prescribes that housing authorities are duty bound to honour the wishes and preferences of applicants regarding the school devoid of a need, choosing. My lords have the language because you've already considered it, but she does not go on to say Alternatively, the journey is manageable. The conclusion of her point on schooling is halfway down page 104. And it is, any reasonable parent would have relocated their children to a school near their residence.
I mean, is this fair that on your case, the question of whether or not there was interference depends at least in part on the review officer's thought process?
As ascertainable
As
from her
ascertainable
words.
by
Yes.
from the
Yes.
Now, is that necessarily right? I mean, that's not looking at the result. That's looking at whether she'd taken into account the right considerations.
Well,
Now, plainly, when assessing suitability generally, leaving aside human rights, if you don't take into account the right considerations, that can be open to public law challenge. But if, as Lord Hoffman says, for the purposes of Article 9, you're concerned with substance,
yes.
even if she thought about things the right way, if there was an interference, well, as a matter of substance, there was an interference. But if she wasn't thinking in any particular way, does that matter in determining what the substance is as to whether or not there is an interference?
It does, because the question for your lordships is whether or not this review decision contains errors of law, and that is a matter of substance. But there is nothing of substance in this review decision that shows that she came to the conclusion that your lordships might come to, and indeed Recorder Dean comes to, that there was no interference. She simply doesn't, because she doesn't acknowledge the, again, respect, significant weight, whatever word one wants to put on the manifestation, she then has one answer and one answer only. And we say first that answer is itself a breach of Article 9. And the fact that she doesn't go through any sort of reasoning process that reflects the law on Article 9 means that answer remains a breach of Article 9 and cannot be construed as the two, again adapting the words from the House of Lords, the two filters that are relevant in Article 9. One is interference and two is justification. So although it is substance, although it is outcome, her outcome, we say, is very clearly a breach, and there's nothing in that outcome in the reasoning to save it from being a breach. Because, I mean, I should be clear, we've concentrated on interference, but again, we say if she was doing the exercise lawfully, she would, having considered interference, she would then have gone on to consider justification. And there are clearly points that can be made around justification, not least the terrible demands on Waltham Forest's housing resources. Clearly that's in the mix.
Yes.
And there are also answers to that, some of which we canvass in our skeleton argument about whether the offer needed to be made immediately, etc., etc. There are points to be made in respect of justification and proportionality. I can develop them if your lordships wish, but to make the general point, there are points to be made there. But she didn't go through that. And although we are dealing with substance, our substance is, we say this is a breach of Article 9, and there is nothing in the review decision that saves that.
I think that puts it very neatly.
And I should say, and that's in contrast to the two decisions by the two schools, where they do have, it's less apparent in the Denby judgment, I should say. It's very clear in the Michaela judgment that the decision makers in those cases went through the relevant factors and did a balancing act in the Michaela judgment. Then the briefing note that the governors were considering about the decision not to have a prayer room specifically does the balance. They acknowledge that this has a disproportionate effect on Muslim students and so forth. So all of the factors that the courts then subsequently say in both of those cases lead to either no interference or certainly to justification. They're in the minds of not just the minds, but the wording of the decision makers. That's not here. What is here, said over and over again, avoiding the temptation to criticise the language, is there is one answer, and that's relocating. May I deal with the respondent's response on ground one? First of all, the respondent says, well, the point about human rights wasn't raised, and refers to the homelessness authorities of Crampton, Hastings and Williams and Birmingham. And my answer to that is twofold. One is that it's a matter of law that a public authority, a local authority, needs to be aware of human rights, and that the facts were raised, the preference for the Islamic school, which should have alerted the public authority to the legal point, and that they were required as a public authority to grapple with the point, to consider the outcome. An example of that is the public sector equality duty, where the authorities are very clear that in order for the review officer to undertake the reasoning process required by the public sector equality duty, that duty itself doesn't need to be brought up by the applicant when making representations, but the facts that would lead to a real possibility that the public sector equality duty might be relevant have to be put in the representations. And we say clearly the fact was, and therefore as a matter of law, it was for the local authority to grapple with it. It was not for the applicant to say, and by the way, the Human Rights Act applies. There's a small point that at one point in a telephone conversation then my client did actually refer to his rights, clearly not in a legal sense.
Well, there was a telephone conversation on the 22nd of September.
Yes.
And we don't know. I
think
don't.
It's 12th. It was just before the Minded 2 letter. It's the 12th or 13th.
It was the 12th of September, is it?
Yes.
Thank you. Do we have that conversation in the record?
We do. It is page 116 in the supplementary bundle. There are actually two conversations. It's a little unclear which way the notes go. They seem to go, as it were, backwards.
Right,
and so it's a little unclear whether it's the 12th or the 13th of September, but nothing follows from that.
Sorry, we just got, I was looking on the following page. 12th of September is appraisal of solicitors' representations.
And then above that, at the top of the page, you'll see a long paragraph, which then seems to be dated 12th of September at 1639.
I've not got that. I see, it's on.
Just about, and that, if my lords then go to the previous page at page 116, seems to be the end of the note of a telephone conversation that starts called up again.
Okay, so 12th September, and then.
And that's where he says.
Telephone call to applicant.
Yes, and 3 lines down, we further discussed the following one. Schools advised App that there are local schools in Harlow, to which he replied that we are not considering their rights. She replied, the review officer replied, there's no legal duty to provide accommodation so that apps can maintain their children's specific religious school. And then there's all the other matters are discussed.
I'm sorry, the reference to rights is at what part of the page?
He replied, we are not considering their rights. It's 4 lines down from the paragraph starting call up again.
Yes, sorry, I'd already.
Yes.
Just
So he used that word.
I follow that. Just prompted by that, is it your position that, contrary to the view of the review officer, there is such a legal duty unless interference can be justified?
Yes. Well, it is my position that she has to recognise it's a right, as in human right. And again, without being tempted to criticise the wording of the review decision too much, then she does embark on a clear, and we say wrongful, binary distinction between what she calls preferences and needs.
Just stripping away the facts of this case from that
Yes.
to test the principle, because we are testing the principle. That's why we're
Yes.
dealing with an appeal that has
Appeal,
become
yeah.
academic. Is it your position that a local authority, where an applicant wishes to send a child to a religious school for religious reasons, has a duty to provide accommodation within reach of the school unless justification allows that not to happen?
It's my position that when considering suitability, his right under Article 9 has to be respected, and therefore there will be a breach of Article 9 unless the appropriate reasoning has been gone through.
It comes back to the substance procedure point. I
Mm.
mean, as a matter of substance, whatever the review officer has thought, the fact is that accommodation is not being provided within reach of a religious school. If that is an interference, then presumably it can only be permissible if justified.
Yes.
Therefore, regardless of what the review officer thinks, it is indeed the case that a local authority has a duty to provide accommodation within reach of the school unless the contrary is justifiable.
That sounds like the starting point, but the point is this, that the right to respect, etc., etc., is the starting point. It's not necessarily the end point, but the local authority can only defend an end point if their reasoning has been such that it is compatible with Article 9.
But the interference is the same, whatever the reason.
Yes, but Article 9 allows for justification.
I'm having some difficulty with this. My Lord has put a proposition to you, which it seems to me you're bound to defend. I mean, you instead moved to saying it depends upon what the decision maker says in her analysis. That can't have anything whatever to do with the substance of the right that is under consideration.
The substance of the right is, yes, that is the starting point. And in that sense, I don't think I'm necessarily agreeing with Lord Justice Newey.
You're not, well, I want to know what the right is in that case that is at stake here.
The right is to manifest his religious belief in the form of sending his children to the Islamic school. And so that is the starting point for the local authority. That yes, we should be enabling him to do that. It can then go on and consider, is that actually interfered with?
Yes, but in the end, what's the difference between what you've just said and what my Lord said a moment ago?
Maybe not.
I mean, it seems to me that to get this off the ground at all, you're bound to assert that there's a duty to provide accommodation in reach of, I appreciate that's a flexible concept, but in reach of the school of choice, unless the contrary is justifiable.
Which it clearly can be in circumstances, including the demands on Waltham Forest resources and so
But that
forth.
is, I mean, that's what we have to grapple with. I mean, and what the reviewing officer was in a non-legal sense addressing was whether there is such a duty.
Well, one of the reasons I'm hesitating is because, of course, she also had to grapple with a number of other matters which are not before your lordships.
Yes.
She has to. There is, of course, the whole list of concepts of suitability, affordability, disruption to other matters, etc., etc. And so on the analysis we're talking about, then she might, for example, be in a very difficult position where she is saying that the only accommodation that would enable your right to be respected is unaffordable, and we have nothing else. So she has to that would go into justification, but it is also in itself its own consideration under suitability, and the overall suitability assessment has to balance all those different factors.
Ian, can I be clear that you are indeed asserting that the reviewing officer ought to have realised that there was a duty to provide accommodation within range of this particular school, unless...
She ought to have realised that was her starting point.
Well, it doesn't matter at what point. At some point in her analysis, she had to realise that there was a legal duty.
To respect it, yes. Yes.
No, a legal duty to provide accommodation unless you couldn't for some justifiable reason. Now, I mean, because we've reached this point, I don't see how any lesser formulation of the obligation on this public authority could get your case off the ground. It has to be that responsibility, doesn't it? That duty.
The other factors that she has to consider under suitability, and I'm not avoiding the question, I'm just going about it in a long way. She has to consider both for themselves. If she has then come to a conclusion that all those other factors are met, but that there is an interference with human rights, then there are two ways of looking at that. One is the neatest way, which is to say there is an interference, but it's justified for a number of reasons, including the fact that I found that all the other factors relating to suitability are satisfied.
Yes, but is this your challenge? I appreciate is to one aspect of the decision, an important aspect of the decision for sure. But you appear to be, at least to me, to be saying that in this respect, the Article 9 element of the suitability decision, that if the place is not within reasonable reach, then there is an interference. Now that's a pretty important statement of law.
I am saying that, but I'm also saying it's not an ace of trumps, both because of justification, and secondly, because all the other factors relating to suitability have to be taken account of.
But
the human right is a very important one, but it is one factor.
But I mean, I quite follow the other factors might make accommodation unsuitable, but the human right element would be a trump card absent justification.
Well, one is there's justification, but two is another way of looking at it is that it's rather similar to the Section 11 Children Act duty, which Nozola Mesa and Westminster City Council considered. Now, my lords will be very familiar with the decision of Lady Justice Hale, which is that the children's welfare, that duty, need not be the paramount or even a primary consideration. However, the choice made would have to be explained. And what I'm anxious to establish is that the human rights is one of a number of factors that she's considering, but it is a significant one. It
Yes.
has more weight
Important but not
than each of
exclusive.
the others. It's
not-
important but not exclusive, not a veto, not an ace of trumps. Need not be the paramount or even primary consideration.
I mean,
It has to recognise its significance.
It's very interesting, but I think it's important for us to see the argument for what it is, because it might seem where you have somebody who's living within your particular borough and doesn't want to go out of it, or is gone out of it temporarily, that saying that it's going to be an interference with my rights if my child is not within range of the school of choice, religious school of choice. And this would translate in some circumstances to an argument that the state was obliged to move people to places which were within range of schools of choice, if there didn't happen to be any in their area. I mean, you've got to consider, haven't you, the nature of the Article 9 right in housing terms, not just for somebody who's near a school and doesn't want to go far, but from somebody who's far away from a school and wants to go near. You've got to consider your client's counterpart in let's say Waltham, not Harlow, just to avoid confusion, who wants to be in Leytonstone.
Well, of course they could, and they could, assuming that they're imminently homeless, then they could achieve that through two mechanisms. One is by applying to Waltham, but the more realistic way of achieving it is making an application to Leyton, to Waltham Forest.
Yes.
They would then, of course, be referred back under local connection. So that would be difficult. But that's one of the reasons I'm struggling to. I'm reluctant to agree with the proposition that there is a duty, because there are so many considerations around homelessness, in respect of suitability, but also in respect of other limbs of the legislation, such as local connection, that to elevate it as the human rights point as a duty doesn't fit with the overall structure of Part 7. But to say that it has significant weight, we say does.
So can I just be clear? So suppose that you live in Penzance,
Yes.
where there may well be no Islamic school.
Yes, let's assume that, yes.
Suppose for the sake of argument, which can't be true, there is no other Islamic school but in Leytonstone.
Yes.
Now, as you say, you living in Penzance apply to Waltham Forest Council, they'll say nothing to do with us. So you apply to Penzance Council and you say, well, you have to provide accommodation close to the Islamic school in Leytonstone. Now, as I understand your submissions, Penzance might well be able to say at stage 2, we've got a justification for not doing that. But do you say that there would be an interference for Article 9 purposes if Penzance didn't provide accommodation close to Leytonstone? Well,
so I say, first of all, on the structure of Part 7, Penzance has the power to do that. That's clear. And so, yes, Mr. X would ask them to do that. And then in their decision making about whether or not to do that, then they need to be, as with suitability, they need to be giving the significant weight to the human rights point. But I also say that we need to be careful. I'm grateful for the scenario. It's an important one, but we have to consider the context. Because, of course, Mr. X in Penzance, who'd like his children to be educated in Leytonstone for those reasons, the scenario only applies if he's become homeless in Penzance, wherever he then applies to, Penzance or Waltham Forest. If he is really concerned, again, I don't want to do down his motivation. If he's already taken steps to find out about an Islamic education, one would have expected him to have already tried to find his own accommodation in Waltham Forest, bearing in mind that homelessness is a safety net. Homelessness is not a method of distributing accommodation across the country. There are other methods of that, social housing accommodation. Homelessness is a safety net for people who, one, are homeless, and then two, have not been helped to find their own accommodation, which is now the starting point indeed in Part 7.
But the chances are, I mean, my understanding is that the London boroughs are consistently pushing people out of London because rents are so high in London.
Yes.
So the person becoming homeless in Penzance could perfectly sensibly say, look, there's no question of my being able to afford a Waltham Forest rent. That's just not a possibility.
Yes, in which case there wouldn't be accommodation available in Waltham Forest that would be suitable for them. And so
That's an interesting point, actually.
So yes.
Suppose it's unaffordable.
It's taking things too far to say you need to pay for me to live in unaffordable accommodation. Now, there is a piece of case law that says in certain circumstances the local authority should do that, but those were very unusual circumstances. And I am not going to suggest that the outcome of this case should be that local authorities should start subsidising people's rents once they've found the longer term accommodation. That would be dangerous for all sorts of reasons.
But would there still be an interference? So in that scenario, no question of being able to provide affordable accommodation in Leytonstone. So in that sense, unsuitable. But would there still be an interference because you weren't offering to provide accommodation within reach?
Come back to justification, and it would be, there'd be 2 points. One is it an interference because on our hypothetical scenario, Mr. X hasn't yet started his children in Islamic education, so the facts about are slightly different. So the interference question would be more nuanced than it is in this case. And then second, we would come to justification. And Penzance saying, one, we don't do this, but two, we have looked at accommodation in Waltham Forest. You cannot afford it, so there is no suitable accommodation. And if you are telling us that we should subsidise you in order to move there, then these are the reasons why that is not justified. Obvious reasons to do with public spending and so forth. And it's hard to see how such a reasoning would contain errors of law.
Yeah.
And indeed, they'd be more likely to say we just don't do this and we can't afford it. It would be quite hard, given the factual background, it would be quite hard then for someone like me to come along and try and unpick that too much, because one is entitled to take into account, to assume that they've taken into account housing resources, etc.
Okay.
I was still on Mr. Mullin's objections. I will try and deal with those as quickly as possible. I think I have dealt with outcome, not process, and I have dealt, I think, with the point that because it's outcome, not process, it's a matter for the court. I say it is also a matter for the reviewing officer. And I've made this, but I should say one word about Article 2 of the first protocol. It's not my principal point. I accept that the second sentence of Article 2 starts in respect to the functions of education and training. And clearly the review officer is, the functions that she's engaged with is that of the provision of homelessness accommodation. So far as our researchers are concerned, we could find nothing on the extent, no case law on the extent of what might be a function of education and training. All the human rights cases are to do with schools. It's obviously a function of education and training. All I say is that two reasons. One is that obviously the local housing authority, as it happens, is also the education authority, but a better reason is that, and we come back to the main point, is that when she was considering her homelessness functions, she was considering where to place a family, and education is clearly a relevant consideration for that.
And I follow the latter. As to the first, does it matter that this particular school isn't one provided by the local authority anyway?
The first, as I say, is a weaker point. She's dealing with the provision of education in general. She's actually looking at Harlow's provision of education, actually, rather than Waltham Forest's provision of education. But I come back to my second and I say better point, which is that she's considering placing families where education is a relevant consideration. And I should just deal with, to conclude on ground one, the Holmes Morehouse point. We entirely accept that there needs to be a benevolent interpretation of the analysis. She's not a lawyer, has to be read as a whole and not nitpicking. And we say, for the reasons that we've discussed, that when one does that, then there is a breach of Article 9 and there is nothing read as a whole and benevolently that deals with the filters that can prevent a breach of lack of interference or justification. Can I move on to grounds 2 and 3, which will be very short?
Thank you.
On ground 2, the learned judge erred by failing to conclude that in the absence of recognition in the review decision that the appellant was exercising a freedom protected under Articles 9 or Article 2, Protocol 1, and the proper consideration thereof, the respondent could not have made a decision that complied with the Code of Guidance, paragraph 128, which requires local authorities to consider the human rights implications of their decisions.
Is that the same point?
It's
the same point in a different dress, as it were, is it?
Slightly. The point is this, that the code, both at paragraph 1.28 and indeed at paragraphs 119 to 121, directs local authorities to consider human rights. That's clearly right because of section 6. If my lords are against me and the reasoning in that part of the review decision does comply with Article 9, then clearly she's also complied with the code. If my lords are against me in another way, then no, I'm sorry, I'll take that back. If you're with me, then I say the point is simple. She either failed to consider human rights, we're back in ground 1, or she somehow made a reasoned decision not to, and the authorities in respect of the code are quite clear that if there is a decision not to comply with the code, then there has to be reasons. That's in the LMA. So
I'm finding
that
it quite
seems
hard,
unlikely.
quite hard to see circumstances in which ground 2 will help you if ground 1 hasn't succeeded, or where if ground 1 has succeeded, you need ground 2. I mean, people always like to draft more than one ground because a single ground looks lonely. But I haven't yet really discovered why we've got more than one ground here. But anyhow,
I'm not going to develop it. My lord has the point. And then ground 3 is the point about language, and again, without criticism of the slightly dismissive air of the language, we do say this, that she fell into error by setting up a binary characterization of preferences, which she said the local authority was not duty bound to take into account, and needs. Clearly it is. Obviously we all agree that it is. And that we say human rights is something different to both of those, and that she failed to recognise that. There is a different submission, which I'm not going to develop today, as to the extent to which preferences might be relevant. But that's not for my lords today. But even if it's right that she could dismiss his preferences, then she certainly could not dismiss in the way that she does the human right.
Isn't this again an aspect of the?
We're coming back to ground one.
Ground one.
Yes. Will my lords just give me a moment?
Yes, certainly. Anything else, Clay?
Those are my submissions, unless there's any other.
Thank you very much indeed, Ms Davies. Yes, Mr Mullin.
My lords, good morning. I'm very grateful to my learned friend for setting the scene, as it were, and doing a lot of legwork. Where I'd like to start, my lords, if it's all right, is really defining the parameters of what's been put into dispute, both on the review, then on the appeal below, and in this court. Because it seems to me that's quite an important question for the court, because although the appeal is now academic and could be an opportunity to rule on some more general aspects of Article 9 or the effect of Article 9, there's a question mark in my submission as to the degree to which the court needs to do so to resolve the issues in this appeal. So that's a long way, my lords, of saying what were the grounds of appeal in the court below, what were the submissions on the review before that, and then what are the grounds of appeal in this court. So as I'd understood the case, and I'll be correct if I'm wrong about this, it was not said to the reviewing officer or in the grounds of appeal of the court below that there had been an act by the respondent that was incompatible with Article 9. That was not a proposition that was advanced to the reviewing officer. It was not part of the grounds of appeal below. The grounds of appeal below, and indeed the grounds in this court, say that this is a matter of proper decision-making and process. That the reviewing officer had to, and the word's been used by my learned friend, recognise, consider Article 9. That, in my submission, can't be right for the very succinct reasons given by Lord Hoffman that your lordships have already been taken to at paragraph 68. Article 9 does not confer a right to have a decision made in a particular way. A very straightforward proposition of law in my submission. That, I'd argued it from first principles in the skeleton from the wording of Section 6 of the Human Rights Act. Perhaps unsurprisingly, Lord Hoffman's put it far better than I did. The court shouldn't be, in my submission, tempted to go behind that and say, well, the reviewing officer had to recognise or consider or reach a conclusion on what the nature of the Article 9 rights of the appellant were, whether they were interfered with, or whether any interference was justified. The way this appeal has been put both below and in this court is that things should have been taken into account, recognised and considered by the reviewing officer. That cannot be right, I say, for the same reasons that Lord Hoffman says in paragraph 68 of Begum. And really that should dispose, in my submission, of much of this appeal. It disposes of ground 1 entirely, in my submission. It disposes of ground 2 in large part because once it's recognised that, putting aside a slightly technical point about the wording of ground 2, so obviously local authorities are only required to have regard to the guidance, they're not required to comply with it. So a decision can't be in compliance or not with the guidance. But putting that to one side, and putting to side that the guidance doesn't require local authorities to consider human rights of applicants in every case, what it says is it creates an expectation that they should consider human rights implications, because otherwise there's a risk that those decisions will be unlawful. That's a matter of common sense because, of course, if you're considering human rights in a decision, you're much less likely, one would think, to interfere with them. But it doesn't create a strict duty to do so. And if my analysis of how human rights law operates, particularly Article 9, in that it doesn't create a process duty, then there's no force in ground 2 either. And ground 3, and I respectfully agree with my Lord Justice Jackson that it doesn't add anything in particular to ground 1. But without putting that point too forcefully, that in my submission disposes of the appeal, and there is no need to go any further than that. The skeleton argument, the grounds of appeal are all based upon the way the reviewing officer went about reaching her decision. And she should have thought about this and balanced that and given this weight and given that weight. That simply isn't the way, in my submission, that the convention has been incorporated into domestic law by the Human Rights Act. Section 6 only renders an act unlawful if it is incompatible with a right. That's as Lord Hoffman says, and indeed I'll just take my lordships briefly to the judgment of Lord Justice Bingham, because in the Begum case at page 506, because Lord Justice Bingham makes the same point in slightly more detail. I won't read it all out because it's quite lengthy, but it starts at paragraph 27 of Lord Justice Bingham, and it runs over a few pages. At paragraph 29, it begins, "I'm persuaded the Court of Appeal's approach to the procedural question was mistaken for three main reasons." And this is, from there on, is Lord Bingham's judgment along the same lines as Lord Justice Hoffman. They're both, of course, in the majority, and Lord Justice Scott agrees with them. Those two dissenting judgments. But the dissenting judgments don't take issue with the fact that the Court of Appeal got it wrong in relation
the issue in this case was to do with a decision of the school in relation to school uniform.
Correct.
Is there a difference when we're considering here a decision of a housing authority in relation to the performance of its statutory duty?
In my submission, no. In substance, no, my lord, because if the legal mechanism is the same, it was being said in that case that the uniform policy was unlawful because it was incompatible with an Article 9 right. The rights under Article 9, and therefore Section 6 of the Human Rights Act rendered that uniform policy unlawful. Now, it has not been said in this case, below or in this court, that the review decision is unlawful because it is incompatible with the appellant's Article 9 rights. That's not been the case, as I understand it. The case has been the review decision is unlawful because it doesn't consider and recognise the appellant's Article 9 rights. So that's the wrong analysis. That's equating the operation of human rights law and how the convention's been incorporated to a duty like the PSED, with which this court is very familiar, particularly in homelessness cases.
And it's paragraph 31 of Lord Bingham that you draw attention to, is it?
Yes, it's so there are so Lord Bingham gives three reasons, and he's I think there'd been some academic criticism of the Court of Appeal's judgment in this case, and he respectfully, I think, agrees with the academic criticism. Gives three reasons, and the third reason is, indeed, I consider the Court of Appeal's approach would introduce a new formalism and be a recipe for judicialisation on an unprecedented scale. The Court of Appeal's decision-making prescription would be admirable guidance to a lower court or legal tribunal, but cannot be required of a head teacher and governors, even with a solicitor, to help them. Yes, I respectfully endorse that.
So is trying to grasp the nub of your submission, is it
Yes.
that by making this, shall we call it, nuanced challenge, which is not that it was unlawful for a breach of Article 9, but it was unlawful for failing to consider and recognise the existence of the Article 9 right,
Yes.
that amounts to a formalising of a technical formalising of a process which is instead intended to look at the substance of the matter. So if the complaint was a more common public law complaint, namely, you simply didn't consider my case about the education of my children
Yeah.
in a particular school, a classic public law challenge.
Well, yes.
You either didn't think about it at all, or insofar as you thought about it, you manifestly didn't give it the weight or consideration that it deserved.
Yes.
That would be a different type of claim to the one that has in fact been brought here.
My lord, yes, it would. If it was said if it had been said to the reviewing officer, or as a ground of appeal in this case, at first instance, the review decision is unlawful because it is incompatible with the appellant's Article 9 rights, that would have been an argument they'd have been entitled to run. I'm not saying it would have succeeded necessarily, but it would be quite a different argument to the one that was run, both in the court below and here. It could also have been run in a different way. It could have been, as my lordship observes, a far more normal failure to take into account a relevant matter. But I don't understand that that's the basis that it's put in this court. The basis it's put in this court is Article 9 itself, as a right, confers the right to have decisions made about you in a certain way. And the House of Lords has ruled conclusively that it doesn't do that. Or that certain matters have to be taken into account in the decision-making process. Human rights legislation is focused on the outcome of acts of public bodies, not the decision-making that leads up to those acts. So there is no duty to consider beyond what the guidance says, which is the point made in ground 2, but there is no public law duty to consider someone's human rights in the exercise of a discretion or power. Human rights come into play when that decision has been made or that functional power has been exercised. And then the question is whether the functional power was compatible or not with a convention right. And that can be called into question in proceedings. But that isn't the route that's happened in this appeal, as I don't want to labour the point too much, but I say from the drafting of the grounds below and the grounds here and the way that it's been argued, that isn't the appellant's case. And the reviewing officer can't be in legal error for not whether it's the exam paper that Lord Hoffman recommends in, that Lord Hoffman deprecates in Begum, or a more subtle, less complex formulation that my learned friend says they should have adopted here. It's really two examples of the same mistake. It's assuming that Article 9 requires a specific form of decision-making when it doesn't.
Well, of course, a lot of things that are encompassed in a housing decision may touch on particular forms of human rights, not just Article 9, could be
Quite.
Other rights that are potentially engaged.
Yeah.
And I suppose the point that could be made to Miss Davies is that asking for something because it might or does come within the parameters of a particular right, and to treat it as if it was somehow special for that reason would make reviewing officers' lives extremely difficult.
Indeed, and I think that was, I'd agree. I think the point that the recorder was making below as well, certainly in the course of the hearing of the appeal between me and my learned friend Mr. Gannon, was that what did the gloss of Article 9, if I put it that way, what did the mere recitation of it or the recognition of it as a right under the convention, what does that add to the analysis that the reviewing officer undertook? And I suppose, which is of course, surprisingly my lords, my fallback position is that if I'm wrong about the duty to achieve a particular outcome versus process duty point, I say there's no reason to find that either the Article 9 right was interfered with, or that there was anything deficient about the reviewing officer's analysis. And I've set those arguments out quite fully in my skeleton.
Yes.
I don't propose to repeat them, but of course the court, having read the review decision, will see that it deals with a very large number of things, not least the location of the property. It's right to say, I think, that it's under a mile from the accommodation that the appellant had been in since 2020. So I think, and I'll be corrected if I'm wrong, that the eldest child had started at the school prior to the move to Harlow. They'd maintained his schooling at the school during their period in temporary accommodation in Harlow. And then when the offer that's the subject of this review and appeal was made, that offer was less than a mile within Harlow from the place they were currently living. And I'd agree respectfully with my lordship's interpretation of the review decision that the reviewing officer is saying, well, things are as they are, they can carry on, or if you want to save money, have more time as a family and have much less stressful travelling requirements, which will assist you in your work and your wife in her work, you could move the children to local multi-faith state primary schools. And in my submission, that would be a benevolent reading of the review decision to the extent benevolence is required. In my submission, that'd be a relatively fair reading.
But I think there might have been some room for some benevolent writing of the review decision. But,
and I think the local authority accepts that.
Yeah.
The local authority accepts that. Advice has been given in that respect as well. But it's difficult. Whilst that can form the basis of some criticism, doesn't form the basis of an error of law, I say. But
so just to talk round it a moment.
Yes, Mark.
I think it's the case, unless I'm muddling my local authorities, that your client sent a lot of people to Stoke.
Yes.
Supposing that the accommodation offered here had been in Stoke,
Yes.
plainly there'd have been no question of the review officer's sort of alternative. Well, you can still manage to get your child to the Islamic school in Leytonstone. It would be quite impossible.
Yes.
You don't dispute, as I understand it, that choosing to send your child to a religious school is a manifestation of religious belief.
I do not.
So in circumstances where it was simply impossible as a practical matter to get the child to the Islamic school from the accommodation you were offering,
Yes.
leave aside what the review officer had said in the decision about her thought process, would that have been an interference?
I was very much hoping not to be drawn by your lordships on what amounts to interference. But I think to the extent that I've understood it, the Strasbourg jurisprudence on interference is quite complicated, to say the very least. And that ultimately what I think in Williamson, which is the domestic authority that's in our authorities bundle, what's said about interference is that what will amount to interference will depend very much on the circumstances in an individual case, which isn't particularly helpful guidance. But it does stress that it's difficult to draw broad general principles about what amounts to interference. And the court doesn't need to in this case, in my respectful submission, because of my first argument in relation to ground one. But
so to put it crudely, in a sense, the further away you were being sent from the school of choice, the more likely it might be that if one performed a human rights analysis, one would find an interference and then move to the consideration of justification.
Yes, my lord, I'd agree with that. But potentially, in terms of interference, so for example, some of the jurisprudence on interference relates to where the person asserting the violation of their right has made some sort of choice that's led to the violation of that right, i.e. they've gone to a secular school and then complained that they're not allowed to wear what they would like to wear or just manifest their religion in a certain way. I think there's a Turkish case involving a member of the armed services who's then prohibited from, or early retired because he started manifesting his religious belief in a way that was impermissible. But what that shows in my submission is that the wider circumstances are relevant. And so in this case, for example, it could be argued that is it the local authority that is interfering in the appellant's exercise of his right, where all it's doing is doing its best to resolve his homelessness. It finds in the review decision, for example, that the school fees are expensive and they're going to get more expensive when his second child starts the school, if they do. It makes a series of detailed findings about the average rental price in Waltham Forest versus the average rental price in Harlow. And it deals with a number of other factors, but it could be said in my submission forcefully that it is not so much the local authority interfering with the appellant's Article 9 rights, because all it's doing is trying to resolve his homelessness. His homelessness is created by other circumstances. He was made homeless initially because he couldn't afford the private rented accommodation he was in Walthamstow. And it's his income, how much he's being paid for his work, how much his wife has been paid for his work, his choice to send the children to this private school and spend the money on that as opposed to spending it on other matters, as the reviewing officer goes into, that creates this tension about where he can afford to live. So that there is at least.
So you're not to be taken to concede that it's simply a factor of distance, that there may be a more fundamental objection to finding an interference arising out of what is in essence an act of assistance, statutory assistance.
My Lord has put it far better than I did, and far shorter.
No, well, I had the advantage of you doing the workings out, but I mean that's the point.
Yes.
But at all events, arising from my Lord's question, we weren't talking about Stoke here or even Penzance. We were talking about Harlow.
Yes, and Harlow. And Harlow is, I think, the review finds it's about 20 miles away or less than 20 miles away from where they were currently living in. They were living previously in Leytonstone, which is within the Borough of Waltham Forest. And so the reviewing officer had to consider the facts as in that individual case. And I've just, in answer to my Lord's previous question, set out the various factors in addition to the preference that they remain attending the faith school that she considered, affordability being a big one. And I think, as I put in my skeleton argument, it's difficult to see how there is no challenge to the reviewing officer's finding that these school fees were not a necessary expense, but that in somehow, so she wasn't in error when she did that, but was in error in some other way. But otherwise that would be a flaw in the affordability assessment, presumably.
Yes.
So the question would be, the question could have been in the court below, was the offer itself incompatible with the Article 9 rights? Was the reviewing officer's decision incompatible with the appellant's Article 9 rights? But those weren't the questions asked below.
I was just looking back at the judgment. Did the judge understand the complaint to go that far? So she deals with the question of whether there's a problem because the review officer hasn't mentioned Article 9.
Yes.
And then she comes on in paragraph 28. She says that the question really is whether the dismissal by the reviewing officer of his choice of school as a matter on which he was placing much weight was an interference. Is that looking sort of beyond the thought process to the substance?
In my submission, yes. So the learned judge below does go further in my submission than the ground of appeal that was actually being raised. So the ground of appeal that was being considered is at paragraph 16. And it's similar to the ground of appeal in this court, not identical, but similar. It's the respondent failed to take into account the rights of the appellant and his family under Article 9 and failed to consider the human rights implications. So
That's then recycled at the last sentence of paragraph 17.
yes. Yes, the appellant's complaint was essentially that no heed has been paid or specifically been said to have been paid
Yes.
to his Article 9 rights.
So it's a sort of it's an oblique appeal to human rights.
Yes.
Which is why it seems to me it's another way of saying you didn't give enough weight to something that was very important to us as a family.
Yes, but in my submission that would have required a very different ground of appeal and the argument to be run in a different way.
I understand the distinctions you're drawing here, but that seems to be what the judge understood
Indeed.
the complaint to be, and that conforms with what we're understanding the complaint to be.
Yes, yes. Well, I don't want to repeat my my submission on ground one, but the court should be wary in my submission of being of converting the way that the convention rights are incorporated into domestic law at the moment, i.e. via this outcome-based prohibition, if I call it that way. It makes more sense to call it, I think, either a prohibition or a deeming provision, Section 6, than creating a duty. Because it doesn't, in reality, create a duty to do anything. What it does is it renders acts unlawful by operation of law if certain factors are satisfied. And if we were to, if the court were to accede to this appeal on the basis that it's been pleaded and run, it would have the effect of, in my submission, converting that mechanism into more of a Section 149 of the Equality Act type mechanism where reviewing officers had to jump through certain hoops, decision-making wise, in order to reach an outcome. My Lords, my original plan, that's I can take my Lords through ground 2 in a bit more detail if my Lords would like. I have relied on the case of Ballog, which is a case about the Code of Guidance and how the Code of Guidance needs to be, the extent to which regard has to be had to it. Again, I've set the argument in relation to that fairly fully out in my skeleton, but I'm happy to run through it. In essence, failure to refer to a specific part of the Code of Guidance isn't determinative. This court held that in Ballog. And where the reviewing officer refers generally to the Code of Guidance, which this one does at the beginning of the review decision, and in other parts of the Code of Guidance, that's a factor in assessing whether sufficient regard has been had to the code. Where the matter isn't specifically put to the reviewing officer, as it wasn't, of course, in this case, in the terms of human rights weren't raised on the review at all. Those are all relevant factors to say that actually the duty is complied with. The duty to have regard to the Code of Guidance can be complied with, notwithstanding a failure to mention a specific part of the code. I should add there was one point, just by way of perhaps nitpicking, but then nitpicking I think is, if not encouraged, tolerated in relation to judgments of the court rather than review decisions. But the Cordona and Mid-Bedfordshire case, I don't disagree with what's said in that case at all, but I think it's worth noting that, as I understand it, the grounds of appeal in that case, which were to do with Article 8, and the human rights grounds, were refused permission in that judgment because they'd been added after the original grant of permission. And so I think that technically affects their precedent value in terms of this court, but just to spell that out.
Right. So it's sensible but not binding.
Indeed, I agree with it entirely, for what it's worth. But yes, it's technically not binding.
So just coming back, you was talking. You say we don't need to get this far, but you say if we do look at the substance of interference,
Yes.
then it matters that what you were trying to do was to provide housing.
Yes.
You weren't providing education. Cadona was a case where the right to private life, is it,
Yes.
was being invoked in the context of the provision of housing, and it was being said, well, a house isn't good enough, there ought to be a caravan.
Yes.
Is that different on your case from what we're concerned with here, or is it really comparable?
It's comparable in my submission. The difference is, so in the same way that, and I don't think we have this authority in the bundle, but we can obtain it if we do, but in the same way that Article 8 does not equate to the right to be provided with a home, in my submission, Article 9 does not equate to a right that, for one's manifestations to be facilitated, if I put it that way, at all costs, certainly. And that it could be argued facilitated or made easier at all. So there's a similarity in that sense, that there are limits on how an individual's rights can be translated into positive duties on behalf of public bodies. And in the same way that Article 8 has been found not to translate into a positive obligation to provide a home, for the local authority to have been wrong in this case, what there would have needed to have been a duty to positively make it easier for the appellant to continue sending his children to the school in question, because the accommodation he was in at the time the decision was made and the accommodation he was offered are not quite next door, but they're very close together.
So there's nothing in Article 9 that requires facilitation, or is expressed in terms of a positive duty.
In my submission, no. I'll be correct if I'm wrong about that. I'm sure I'm a learned friend, but no. In my submission, the right is to manifest one's religion, and limitations can only be placed upon that right in the normal way. Nothing in that in my submission equates to facilitation. I should add in relation to the protocol, the point about the protocol.
I'm sorry, just before
Of course,
leaving this point, the judge touched upon this at paragraph 30.
yeah. Indeed, I'd respectfully endorse that view.
So for example, I mean, it's one thing to knock down a place of worship.
Yes.
It's another thing for there to be an obligation on the public authority to build one.
Quite. Or to provide faith schools, state-funded, because there are, of course, state-funded faith schools. And so why, if the local authority had to make it easier, why couldn't it be required to build a sufficient number for all the people that would prefer for their children to attend them? No doubt there are many people, I think the court could probably take notice of this, many people up and down the country would prefer to have their children educated in a religious setting, but don't have the option because of the circumstances they're in. Are the local authorities in question, the local educational authorities where those people live, interfering with their human rights by not providing those facilities? Bearing in mind, an act for purposes of Section 6 can include a failure to act.
Yes.
I was just, my lord, going to refer briefly to the case regarding Article 2 of the first protocol. And in my submission, it's simply not arguable that in exercising its homelessness function under Part 7 of the Housing Act 1996, that it's assuming a function in relation to education and training. It would be there's no case that says that. I suspect in my submission, because it so obviously couldn't be described in that way. I've been racking my brains trying to think of a sort of slightly facetious analogy or other example that would demonstrate that, but I'm struggling. I mean, what one could, if the local authority in collecting waste from outside a school, for example, is it in its function to take away bins and rubbish? Is it then assuming a function in relation to teaching and education? In my submission, plainly not. And actually, that would have a closer locus in some ways than the function in this case. I might turn my back on for a second. Thank you, Lord. Sorry, I was just checking if there was. I think it's fair to say that in the way it's described in Williamson, that second sentence again, it's incompatible. So there have been arguments about whether, and in Cousins, which is in the authorities bundle, where the discipline and the disciplining of children, the corporal punishment cases, are functions which it assumes in relation to education and teaching. And I think it had initially been argued that things ancillary to education and teaching, like the disciplining of children, were not properly within that function. And the courts found against that it was a broader meaning that could include things like the administration of the school, so uniform policies, and it could include things like policies on corporal punishment. But where the local authority is exercising, it has its different statutory hat on as a local housing.
Just for our note, we don't have to turn it up, but I think that Ms Davies refers to this in paragraph 29 of her Skousen argument.
Indeed.
The Campbell case.
Yes. That is, we say there is no, that it is simply impossible to read the function that the local authority is exercising in this case as a relating to education or teaching. It only relates to education and teaching in the most oblique of possible ways, and that's not plainly not enough in my submission. So that's the only place that we can find respect, the respect element in a right sense in coming into this appeal. So Article 9 itself doesn't contain the word respect, whereas the second sentence of Article 2 of the first protocol does, in that the state shall respect the right of parents to ensure education and teaching in conformity with their own religious and philosophical convictions. But if that second sentence is out and doesn't apply to local authorities on their homelessness function, then there is no legal duty on us in relation to respecting that right. In relation to ground 3, my lords, my learned junior was going to address the court with the.
Thank you very much.
Not at all.
Yes, Ms Taylor-Waller.
As indicated today, when considering the proper construction of Article 9 as a matter of outcome rather than procedure, this ground must fall away. And so I don't intend to rehash the submissions my learned leaders made today. So in far as there remains any criticism of the procedure taken by the reviewing officer or the learned judge decision, we say that there isn't when taking away that human rights, but in the characterisation of the process as dismissive or arbitrary, we say is not correct. In light of the submissions made by my learned friend on ground 3, I'm not sure that it's necessary to make my submissions in relation to the consideration of preferences and of needs under section 189A of the Housing Act. So I just say this. A fair reading of the decision, even with the recognition of the criticisms that we have discussed in court today, my lords, shows that in substance the reviewing officer made a balanced decision and went about an exercise attributing weight to various points and that was especially in the background of the review, in light of the representations of how they were presented by the appellant to the reviewing officer. Subject to rationality, which has not been challenged, the conclusion reached was open to the reviewing officer. That has been accepted, if not today, but my understanding at paragraph 46 of the appellant's skeleton. That approach was envisioned by statute, and the learned judge was simply correct in her analysis at paragraph 22 of her decision below. I don't believe there's much more I can add that has been today. So unless there's anything by my learned leader that's to conclude, we would say that that ground also fails.
No, thank you very much indeed.
My lord.
Unless there's anything else from me, my lords. That's...
Thank you. Yes, Ms Davies, any reply?
My lords, just a short reply, and it's solely in relation to ground 1. I'm leaving ground 2 and 3 for
Yes.
my lords to consider. And it's this point about a binary position between outcome for the court to decide, as my learned friend says, and process, which is not a matter for human rights. That's my learned friend's submission. And we say, not unlike the binary characterisation of preference and needs, that is too binary. But here we have a third thing. We have a human right, which should have been recognised. It should have been recognised on the facts that were put before the reviewing officer. There was no need to say, and by the way, it's a human right. I don't particularly rely on the telephone conversation we all looked at. What I rely on is the fact that what I rely on is the representation that he said, as a matter of fact, his preference is for the children to continue attending the Islamic school. So that fact was put before them. And I say that there is within the spectrum of outcome as against process, there is something in the middle, which is that when a human right arises, it should be recognised, and that needs to be properly put into the mix. And I say that as a result of her failure to do that on my case, then the outcome of the review decision is that there has been an interference with his right to manifest his religious belief.
Just think about, you've put it very nicely as being a third thing.
A thing in the middle is probably a better way of putting it.
It might be a second thing, but you know, something different, because it has a human right flavour to it.
Yes.
I mean, that would be bound to apply, wouldn't it, to various other sorts of human rights?
Well, my lord said that to Mr. Mullins, and so my learned junior and I were thinking about that. It's hard to, again, one has to be careful about hypotheticals, but it is hard to imagine the extent to which other articles, save for Article 8, which I'll come back to in a moment, are likely to apply within a homelessness context. It seems to us that the relevant ones that arise are Article 8 and, as it happens, Article 9. It might be thought surprising that in 24 years of human rights law, that Article 9 within homeless has only arisen in this case.
Well, it's always when there's when a new thing comes up, one's left with two possibilities. One is that it is indeed surprising that nobody has lighted upon this truth. The alternative is that it hasn't come up because it isn't valid.
Well, that might be the reason.
I mean, in a sense,
my lords
rarity is always a bit difficult.
My lords will make that decision. But what I say is, it's hard to see how Article 3, torture, inhuman degrading, prohibition of slavery, right to liberty, and so forth, would necessarily come up within a homelessness context. No doubt we could all try very hard and think of such scenarios, but they're not. There's no obvious scenario. The two obvious scenarios, or indeed Article 10, freedom of expression, or I could carry on, Article 11, etc. So the two obvious ones, I say, are Article 9, and we're here, and Article 8, And insofar as Article 8, I mean, it has come up, and it came up in Cadona at an early stage. And the answer to why don't human rights come up more often within the context is that it would be Article 8. On my submission, it's hard to see how the others could come up. And Cadona, I accept the point that it's not actually binding, but Cadona is an answer to that. And it's also, as my Lord said, a sensible answer, because Article 8 is not a right to a home. That's clearly established. And it's established from the wording of Article 8. It is a right to respect for your home, private life and family and so forth. And overall, the structured decision making within homelessness decisions comply with Article 8. They do, whilst not saying so, they do provide respect for somebody's private life and family and so forth, because those are matters that not implicitly, those are matters that are actually taken into consideration when reviews officers are going through the checklist of things they are told they're required to take into consideration under the suitability order and so forth. So the whole structure of homelessness complies with Article 8. So the point doesn't arise.
Explore that for a moment. So suppose you have a couple who are divorced and one parent has custody of a minor child. And the question arises of where you're going to accommodate the other parent, say the father.
Yes, and that's relatively common.
And that's relatively common.
Yes.
Now that could have an Article 8 aspect, could it?
Yes, I mean that was the scenario in Holmes Morehouse in the House of Lords. So Holmes Morehouse is important for that scenario as well as the benevolent approach. And broadly, the House of Lords held that there was not an obligation on a local authority to provide 2 homes where a child already had 1 home. Would my lords give me a moment? Do you have it? Could I have it?
What I mean is, and I follow the point about Holmes Morehouse, but what I mean is, if a review officer in a decision addressed the question of the desirability of the father being within reach of the minor child, touched on the question of whether the father should be given accommodation large enough to accommodate the minor child, but didn't say anything showing that special respect had been shown to the Article 8 right to family life, therefore the link with the minor child, would that be open to challenge?
Well, I've just glanced at Holmes Morehouse, and my Leonard Junior is going through it now, and it seems that Article 8 was not an issue in that case. It's not referred to in the head note, and Mr. Gannon is checking. I mean, maybe it would. I don't want to say that it wouldn't,
because that would be a rather closer parallel.
It would be a closer parallel, but the bearing in mind that in any event, Part 7 of the Housing Act is headed keeping families together, and the provisions of it clearly require that families should be kept together. That's section 176 of the Act, which is a definition of members of the applicant's household, everyone who's living with them, and any who might reasonably be expected to live with them as a member of the family. So one can argue that my earlier point that the whole structure, both of the legislation and of the statutory instruments, and indeed of all the matters developed in case law that are relevant to local authority decision making in homelessness, is overall compatible with Article 8. And then within certain scenarios, my Lord Newey's scenario of the separated family, the scenario that we have in Cadona about special attention being given to the cultural requirements of gypsies and travellers and so forth, then we know that I would say from Cadona, we know that in principle, again, without necessarily specifically referring to it, the local authority has to be aware of the substance of the respect for family life or private life in the Cadona case. And that their overall decision has to comply with that.
Yeah.
And that's why I say that Mr. Mullins's attack on our grounds, both in the court below and here, is misconceived. Because insofar as we are talking about process, insofar as we do talk about process, we talk about process on the basis that the local authority failed to save themselves from a breach of Article 9, and that the starting point is that the decision that he could change schools was an interference, and therefore there is a breach of Article 9 as a matter of substance. And the process applies by us recognising that that wouldn't absolutely happen in all review decisions, that a local authority could go through the reasoning and take certain matters into account, and therefore there wouldn't be a breach of Article 9, but we say that the current outcome is a breach. We also say, and it will be a matter for my lords to decide, but that it is not possible to read the review decision, however benevolently, as containing an alternative that you can continue to make the journey. That's simply, it's not implicit. It is, on the facts, it is possible to see that, and it is possible to argue that, because he had been undertaking the journey while he was in temporary accommodation. If that had been raised, we would say that there is a difference between what somebody is prepared to do in temporary accommodation when they know it's temporary, they're prepared to put up with certain conditions for a certain period, and what they are expected to do if they are given what could be referred to as longer term or permanent accommodation. So that we say there's an answer to, well, you've been doing the journey for the last 1 year before the offer, 2 years before the review decision, and therefore you can continue to do that. But we also say that is simply not in the review decision, not even on a benevolent reading. The other point we would make about the relevance of human rights and process is in Connors, and that's at page 181. And that's, as my lords know, another gypsy case, in this case, eviction for a site without the Connors family having an opportunity to answer the allegations made against them of nuisance behaviour, which formed the basis for the local authority's decision to bring summary possession proceedings. And what is said in relation to Article 8 by the European Court of Human Rights at paragraph 83, page 181, is the procedural safeguards available to the individual will be especially material in determining whether the respondent state has, when fixing the regulatory framework, remained within its margin of appreciation. In particular, the court must examine whether the decision-making process leading to measures of interference was fair and such as to afford due respect to the interests safeguarded to the individual by Article 8. And on the basis that Mr. and Mrs. Connors hadn't had an opportunity to answer the case against them, then the legal framework was held not to be compatible with Article 8. So we do say that there is, within, as far as Article 9 is concerned, that there is a process element, and the procedural safeguards in respect of Article 9, we would say, is the reviewing officer recognising the significance of the manifestation and then going through a form of structured decision making before she can find that there has not been a breach, not in the exam paper suggested by Lord Hoffman,
Well,
but sufficiently.
I'm wondering what the difference is, a form of structured decision making.
Well,
It sounds a bit like an exam paper. I mean, I'm not saying it's a bad thing, but it's
the difference comes from the cases in both Denby and TTT, and it's particularly obvious in TTT because in that Mr. Justice Linden was considering the decision of the governing body, and it's page 552. And the governing body had a briefing note from the head teacher to decide whether to continue the prohibition of prayer rituals. And in that briefing note, all the matters that Mr. Justice Linden then found did not constitute an interference were set out.
I'm afraid I wasn't keeping up. Which paragraph?
I'm sorry, it's page 552, and the briefing note starts at page 118,
Yeah.
paragraph 118, and at 119, the head teacher is saying, in terms of the reasons for not providing a prayer room, it would foster division amongst pupils. Contrary to the school's ethos, it's not clear whether that's a different reason or part of the first reason. Lack of available space, lack of available staff to supervise pupils. Pupils would miss important school activities, including during the lunch break. There was no prohibition, but until recently there had been no interest. And then over the page at paragraph 121, this seems to be a quote, not so much from the briefing note, but from the head teacher's witness statement to the court. But she says the decision to ban prayer rituals was not taken lightly, recognised it was a particularly important religious season for Muslims at Ramadan. Many Muslim pupils felt able to save up their prayer until the end of the day, Qada. It's clear that some felt that this is not permissible.
now what is the point that's arising?
So my point is this, I'm sorry, which is that as a matter of fact in that case, and similarly in the Denby case, the decision makers had gone through all the relevant factors, and those were their reasons for coming to the decision. And we see the reasons in TTT at paragraph 125, page 554.
And you say
So-
that supports a conclusion that in principle, and as a matter of law in fact, that there has to be structured decision making?
That there has to be decision making that sets out the reasons why the offer of accommodation is suitable, despite the school not being within travelling distance, which, as I say, is our case on the
That's this appeal. I mean, this has not been a reasons challenge.
No.
Still less has it been a rationality challenge.
No.
So I mean, I feel that we're morphing here into something different. I mean, this is not to diminish the nature of your appeal, but your appeal is made of much purer material than an ordinary old reasons or
I'm not saying
rationality
this
challenge.
is I'm not saying this is a reasons challenge. What I'm saying, it's the second sentence in my ground one. There was no such recognition in the review decision, and the respondent did not consider Article 9. And as I said, I'm not saying she has to say Article 9 manifestation, interference.
But
She doesn't have to use those words. But
it isn't about. I mean, this is now inviting us to embark upon consideration of the needs for structured decision making in housing decisions, which is not squarely within the grounds of appeal.
What I say she has to do, and I say that it is part of my ground one, is that she has to advise herself of all the facts that are relevant to an Article 9 decision. She has to recognise the importance of religion, and she has to consider whether there is an interference. As I said, if this review decision on its face, and with no dispute, said you can change schools to Harlow, or it's my view that you can continue to do the journey, she doesn't then need to She doesn't then need to have a following sentence that says, and therefore there will be no interference. It is any court will take the view that that means that there has been no interference, as it did in the Denby case.
Are you? I'm sure you've made this clear before, but just because we're in this passage of consideration, are you saying that that the reviewing officer has got to decide whether there's been an interference with Article 9?
The reviewing officer has to understand the significance of the facts that were put before her. In terms and has to understand the importance of sending one's child to an Islamic school for the purposes of religious belief. And I'm deliberately not using the words of Article 9.
Yes, well, because a moment ago you said she had to consider whether there's been an interference, which immediately drags the reviewing officer into consideration of Article 9, which she may or may not be aware of.
Well, so she has to understand the significance.
Right, so you're not saying that she has to consider whether there's been an interference.
Then she has to consider whether, in fact, and it's hard to find a formulation that doesn't use the word interference, because I am clear she doesn't have to use the same language as Article 9, but she does have to.
But interference with what?
With a manifestation of his religious belief. In this case, the importance of sending a child to the religious school. She has to understand that. She has to.
So, well, I mean, we can't have it both ways. You're not saying. I think your ultimate position is that she's got to consider whether there is an interference, because that could only be an interference with the right to manifest one's religion.
As a matter of law, she has to consider that. She doesn't have to use that language in order actually to have lawfully decided the matter. But she does have to have taken into account, to have considered facts that are relevant to an interference. And we say because she didn't, because this is not a reasoned challenge, because she didn't, then on the face of the review decision, it is a breach of Article 9. And we say she could have saved herself had she went through a reasoning exercise which set out the facts that led her to the conclusion that sending your children to school in Harlow was either not an interference or was
That's the case on your
justified.
submission, even though in the very clear and moderate letters that were written on behalf of your client, none of this appears at all.
Well, what appears is the principal representations and review, which is the 13th of April, and what is set out is the preference for
Yes,
attending the school, and that is
the primary case,
page 74 in the
73.
supplemental bundle.
73, 74.
73, 74, it's the top of 74, and it's that paragraph 8.
Well, start at paragraph 3.
Yes.
And then we go on to paragraph 6.
I'm sorry, 6. I didn't have my
Yeah, so-
glasses. It was 6, not 8.
Right,
That's the key paragraph.
right, this is a lawyer writing,
Yes.
and they don't embark upon a structured argument.
No, they put the fact. The fact is, they
But,
are.
I mean, it just does seem a bit counterintuitive that you're saying the lawyer only has got to put facts, but the non-lawyer has got to either carry out or emulate a legal argument.
the non-lawyer is acting on behalf of a local authority, carrying out her homelessness functions and required to comply with the Human Rights Act. And yes, she has a difficult job, but that's what she has to do. The lawyer's job, yes, of course, he could have said, oh, by the way, this is the approach under the Human Rights Act, and it's a breach of the Human Rights Act. But he didn't need to do that. All he needed to do, whether it came from the lawyer or from the client the appellant directly, is to set out the fact that there was a manifestation of religious belief without using that word, which is the attendance at the school. And that, as my lord says, that the distance from our client's place of work and his son's school, that the distance, in effect, and this is me adding words, makes it untenable. Right. So the fact is there, and that should have triggered the understanding of the legal position.
Thank you.
One more point. My learned friend was making the point that Article 9 doesn't require, in some senses, facilitation of the manifestation of religious belief, and he said, well, it doesn't require the state to build religious schools, etc. And clearly that's right. He compared that with Article 8 and made the point that Article 8 does not require somebody to be provided with a home. It requires a right to respect for its home. And that is the difference in wording between Articles 8 and Article 9, because Article 9 does set out the right to religious belief and the manifestation of religious belief. The second point on that is that there is a difference between, and it does come back to the discussion about Penzance, but there is a difference between somebody saying, you have a positive duty, you need to build me an Islamic school, you have a positive duty to do something that's not already there, and an interference with what is an existing arrangement, which we say is an existing manifestation of his religion. In other words, the attendance at the school is already in existence. And given that, we're not saying that it is a positive obligation to facilitate something new. We're saying that something that interferes with that attendance then does clearly fall within the manifestation of the religious belief. And the very last point I would make is that when the courts analyse whether or not there has been an interference, and in the schools cases, a lot of weight was understandably placed in both Denby and TTT on the fact that these two young women had, or their parents had chosen to attend the school. In each case, they had been attending for some 2 or 3 years before the relevant issue arose. They'd been complying with the rules, and there were alternatives of other schools that, in fact, in the Denby case, then SB had, I think, already gone to another school by the time the case is considered by the House of Lords. That is a very different choice to the choices available to my client, because he is, of course, he is homeless, and one has very little choice as a homeless person. Clearly, he had a choice to continue to send his children to the school. He exercised that choice, but he had very little choice available to him about where he might be accommodated. That is different from choosing to join a school, from them being there 2 or 3 years compliant with the rule, and for there to be alternatives that were relatively accessible, in a way that finding alternative accommodation is one knows is difficult. My lords, is there any other matter?
No. Thank you very much indeed.
No, great.
Ms. Mullin, not an expectation, but just in case there's anything from either of the further authorities we referred to that you want to reply on, you're welcome to do so. But
But I'll be incredibly brief. It's literally to one, just in terms of the pinning down of the scope of the appeal. Again, of course, we're not in a reasons challenge. It's not been a reasons challenge, but also I'm concerned a little that we're morphing into we are saying either the offer or the review decision was incompatible with Article 9, rather than making a process.
right.
argument.
Well,
But
I was
I've made those
particularly
decisions.
focused on the authorities which we hadn't touched on
No,
before.
I
but
won't.
nothing on
My
this.
lord.
All right. Well, can I sincerely thank you all in whatever roles you've taken for the way in which the appeal has been prepared and argued. We've had some interesting discussions to have in order to give our decision. You'll be aware that we won't trouble you after today to return to receive our judgments. We'll let you have them in draft for you to suggest any editorial corrections and to provide, please, a draft order reflecting our decision. It'll then be handed down electronically at a future date, which won't require your attendance at court. But our thanks once again.
Thank you, my lord.
What, right,